So good afternoon, everyone. Welcome to the Migration Policy Center webinar, Alternative Pathways for Refugee Protection in the Global South. I'm very happy to introduce and to be chairing today's webinar. My name is Sergio Carrera. I'm a senior research fellow at CEPS and a visiting researcher at the Migration Policy Center at the EUI. And I'm also the coordinator of a Horizon 2020 project called ASILE project. This event falls within the scope of ASILE, and this is a multi-annual research project funded under the Horizon 2020 program, which deals with the United Nations Global Compact on refugees and the EU's role in implementing the Global Compact. And today is a great opportunity, a very timely one, to present some of the research findings that the project has so far accomplished in respect of some countries which happen to be main hosts of refugees and international protection beneficiaries. Just to, of course, this is a very timely moment in the European Union because of the war happening in Ukraine. And at the moment, we know from UNHCR that by now we have around more than 650,000 people who have escaped Ukraine and searched for protection in few European countries. And the estimations for the weeks and months to come are equally important. UNHCR is forecasting around 4 million people potentially to move to the European Union. Now, when looking at the situation in Ukraine and the forced displacement of people from Ukraine, this event also will help to contextualize comparatively how other countries around the world have been dealing with similar situations, people fleeing from war, from conflict, from systemic human rights violations. For instance, we will deal with the situation in South America. We'll be looking at Leisa Brumat, a research fellow at the MPC. We'll examine the situation in Brazil, there with the Venezuelan forced displacement, countries like Colombia hosting 1 million, more than 1,700,000 refugees, or countries like Peru, 1 million. And we will have also a presentation by Meltem Seger, Süleyman Demirel University on Turkey, also their Syrian nationals, Turkey hosting 3.700 million Syrian nationals. So when we look at what the EU is currently facing, not only the numbers are important, but also the responses that these countries have been implementing. And the potential lessons learned, what are the key issues that we can draw from experiences in these countries to take in this challenging and quite dynamic moment for the EU, historic moment for the EU. Just today, the European Commission proposed for the first time the activation of the 2001 Temporary Protection Directive that is expected to be discussed and hopefully adopted this week by EU member states. Temporary protection status is something that other countries, amongst the ones we will be studying today, have been granting to asylum seekers. While temporary protection provides group recognition and brings about a number of very positive potentials, it also raises a number of concerns and questions that we will be also exploring today. So I will start by giving the floor to Leisa. The presentation of Leisa is Migrants or Refugees, the non-differentiation between legal categories in Brazil. Leisa, you have the floor.
Thank you very much, Sergio. Well, let me share my screen with you. Can you see it well? Great. So, as Sergio just mentioned, this is a presentation that is based on the ASILE project. I will give some of the findings for the case of Brazil in particular, of the work that we have been doing here at the Migration Policy Center for the second work package of the ASILE project, focusing on the actors and the networks in Brazil. Some of these findings have already been published if you're interested in a blog, Migration Policy Center blog that was published at the beginning of January, and we can share the link with you. And I'm also developing some of these arguments that we present here with other two colleagues, Felina Fraya and Victoria Finn. So basically, the main point of this presentation starts with the fact that Brazil in the last 2 years made two policy decisions that challenge the clear-cut categorizations of migrants and refugees that prevail in global north countries. First, Brazil legally distinguishes between these two categories, migrant and refugee, but in practice, these two categories of persons have the same rights, almost the same rights. And at the border, what happens in practice at the Brazilian northern border is that Venezuelan nationals themselves are the ones who state their preference as to whether they want to apply for migratory or refugee status. And that seems to be quite contradictory or puzzling if we see what happens in some global north countries that make these very clear-cut decisions. So what can we learn from the Brazilian case? First, a little bit of context, very fast. As many of you know, Venezuela is currently undergoing one of the largest forced displacement crises in the history of the region and in the world. In the last 6-7 years, more than 5 million Venezuelan nationals have left their country, and the vast majority of these people are currently residing in other South American countries. As you can see in that map, the darker colors are the countries that are hosting most Venezuelan nationals. Brazil. Why Brazil? Well, Brazil is currently the 5th main receiving country of Venezuelans in the world and the 2nd largest recipient of asylum seekers, of Venezuelan asylum seekers. The total Venezuelan residents by October 2020, now the numbers are much higher, but we don't have the official numbers, unfortunately, was around 261,000. At the end of 2020, Brazil had recognized 47,000 Venezuelans as refugees, and there were 90,000 pending decisions. Well, while Peru, for example, by then, by the end of 2020, had only recognized 1,000 Venezuelans as refugees. This means that Brazil experienced a 5,600% increase in the asylum requests in 8 years at the national level. This is an enormous increase for the state to process. Most of these people are concentrated in Roraima, which is a northern state that you see there in a darker red color. And this is very important to understand the Brazilian response to this, is that Roraima is a state that is relatively isolated from the rest of the federation, geographically, and that has very limited capacities. Which are the options that Brazil faced in front of this large displacement? Well, I will argue that Brazil basically had 3 options. First, to bring migratory status. The second, to bring refugee status. And the third, to just keep Venezuelans like that in an irregular form. Brazil chose the first 2 options, which are to give migratory status and refugee status using some of the policy instruments that the country already had and was already implementing. The first one is the Mercosur Residence Agreement that provides a 2-year residence permit and almost equal rights to Brazilian nationals except from voting in national elections. The second one is to provide refugee status based on the provisions of the Cartagena Agreement, which is an extended definition of refugee, which basically states that in conditions of generalized violence and violation of human rights, then people can apply for refugee status. Based on this, based on the definition, Brazil recognized 47,000 persons in 2019-2021. As a result of this mixed strategy, Brazil has the highest regularization rate of Venezuelan nationals in all of South America, 74%, against an average rate below 50% in the rest of the countries. The point is that now, in practice, Brazilian authorities are granting refugee and migratory status to Venezuelan nationals, regardless of the reasons why they left their country. They don't focus on the reasons why they left. They're just using migratory and refugee status as regularization venues. Why? Well, in another article that is currently under revision with Andrew Guedes, we argue that this is because of an interplay between domestic, structural, and international factors. And it's very important in this triangle to understand the structural factors, that is, bureaucratic expertise and the state capacities, especially in northern Brazil, and the influence of international actors, especially UNHCR and funding by the US to pursue this policy approach. What does this mean in practice? Now, is this a policy implementation failure? Because Brazil in practice is not really applying the definitions, the legal definitions of refugee and migrant in practice. So can we say that this is a policy implementation failure? And what can we learn eventually from this policy approach? And I will provide some evidence first on the non-differentiation between migrants and refugees. A very high-level official of Brazil in our field work, we did 28 interviews with key implementing actors, international organizations, civil society, and especially the key members of the government that are currently implementing these policies. A very high-level official of the government said that Venezuelans can choose whether they would like to live in Brazil as refugees or residents. It's their choice because they know what is best for them. But Brazil basically recognizes all Venezuelans as migrants and also as refugees. Asylum in Brazil is more of an authorization for residents than a status for protection. So the protection approach is not really evident. Regarding access to right, this is an official of the Public Defender's Office. We do not make any distinction between migrants and refugees when we interact with these people. So, as this person, as this official just said, migrant and refugee status is just a venue to increase regularization. From the perspective of the states, having different venues for regularization is a pragmatic choice. It's aimed at increasing the capacity to provide regular status to more people. For example, another public official said that works in the CONARE. The CONARE is a national office that processes asylum requests. They said that they found themselves with more than 100 to 100,000 asylum requests, and they didn't have the capacity to interview all these people and to process all the information. So they thought about giving group recognition. Given what is happening in Venezuela right now, they were allowed to apply the Cartagena definition. Another official, an international organization official, said that in operational terms, the federal police is more convenient for them, for the federal police, to provide residents migratory status rather than refugee status because of administrative reasons. So in practice, the federal police is currently encouraging people to apply for residency, migratory status. Which consequences does this policy approach have on access to rights? Well, in terms of access to rights, they are very, very similar. So an asylum seeker or a migratory resident, they will have access to public services like health systems, schools. They can legally work, both of them. The main difference is that migrants can be legally deported, while refugees cannot. So refugees have more guarantees against refoulement. So if Bolsonaro one day decides not to provide any more residency permits for Venezuelans, then refugees are guaranteed non-deportation. As I said at the beginning of this presentation, does this increase refugee agency? Does this somehow empower them? The choice between migratory and refugee status is frequently based on the fact that many Venezuelan nationals don't have the documentation to apply for migratory status. So they decide to apply to refugee status instead because it's more simple in terms of the documentation. So another official said that Venezuelan national who cannot complete the requirements for migratory residence has refugee as an alternative for residing legally in Brazil. Another reason why migrants and refugees, individuals themselves, may apply for migratory status instead of refugee status is that they can travel back to Venezuela. While if they have refugee status, they cannot, they have to, it's a very long bureaucratic process, they have to ask for authorization, etc. So if they are legal residents as migrants, they can go back to Venezuela. So whereas and a lot of this population has been doing circular migration between the border between Brazil and Venezuela for years. So they can keep doing this in case they would like to. So some final thoughts to share regarding this particular policy approach that maybe is not that particular, let's see. First of all, is that the non-distinction between migrants and refugees in Brazil is a pragmatic decision to increase regularization capacity, and eventually has the consequence of somehow empowering forcibly displaced persons up to some degree, up to some point. So what Brazil is doing is that it is using policy instruments that it already has. It's not creating anything new. It's using the instruments that the country already has to increase the capacity to provide more regular status. Then we can also think about the policy and the theoretical implications of the binary migrants versus refugees. So think out of this binary box and to nuance the picture of the binary migrants and refugees. A lot of the literature often assumes that the state policies and international organizations make these clear-cut distinctions between these two types of migrants and offer different sets of rights to each category. The Brazilian case, and what this literature also assumes that refugee status offers more sustainable protection. The Brazilian case shows that the meaning of protection changes, and it changes depending on the context, depending on the implementing actors, depending on many things. So maybe refugee status is not always the more sustainable venue route for protection or for increasing rights. See also the Colombian case. Colombia, you can see in another article that we have published in the ASILE, for an ASILE publication in the ASILE forum. We can see that Colombia created a new instrument providing a 10-year residence permit to the almost 2 million Venezuelan nationals that are currently residing in its territory. So increasing venues for regularization, independent of the case, independent of the reason that motivated these people to leave Venezuela. So the case of Brazil is illustrative of some wider dynamics that shed light on the complexity of policy decisions beyond the implementation gap. What I'm suggesting here is that maybe we should think beyond policy implementation failure. A lot of the literature affirms that public policies in general terms fail, especially migration policies, and especially in the global south. There is a lot of literature saying that there is a policy implementation gap between laws and practice, and that policies fail. Well, this shows us a much more nuanced picture, and maybe these gaps between legal, the legislation, and practice are somehow explained by conscious decisions to do so that are based on broader explanations such as state capacities. And that's it. Obrigada.
Thank you. Thank you so much, Lisa, for your fascinating presentation, and indeed extremely relevant for the current, reality across Europe and the thinking that the European Commission and European institutions are currently, conducting as to how to respond to the Ukrainian war. I mean, I find extremely interesting how your research shows that the more that policies limit individual agencies, the more chances there are for ineffectiveness, and how important it is to keep in mind the choice of people, the agency and the express, choice of people to self-relocate and to move, and how the framing in some of these South American countries contrasts so much with the policy responses we've been seeing until now in Europe. You mentioned the additionality, so the possibility for people to choose between regularization or submitting an asylum application. Also, this is a really interesting aspect. And the, normalizing regularizations that in fact happen most often than we think. And as the way to, or as an alternative to many policy questions that are being examined. Just as a comment for the Brazilian official as regards non-refoulement, that just as a reminder that non-refoulement is equally solid and binding, not only in the Geneva Convention, but also other human rights instruments which are legally binding, including not only the United Nations Convention Against Torture, but also the SCPR. So thank you so much, Lisa. So next presentation is by Meltem Siger. Her title for the presentation is Temporary Without a Limit, ? A critical overview of Turkey's protection laws and policies. Meltem.
Thank you, Sergio. Good afternoon, everyone. I would like to first thank MPC and Liza for the invitation for the seminar. It's a pleasure to be presenting. So today I will first try to share my PowerPoint. Yes, hopefully it works. It is working, isn't it? Yes, good. Good to know. So today I'll be talking about temporary protection of Syrians in Turkey. We have done within the scope of the ASILE project that we have country fishes on Turkey, and this is a topic which we also examined in the country fishes, but there will be also further project outcomes about protection of Syrians and other refugees and asylum seekers in Turkey. So today, in my presentation, I would like to first make an introduction to asylum system in Turkey and protection of Syrians in Turkey. For those of you who are not very familiar with the Turkish asylum system and the migratory pressures Turkey has been facing. Secondly, in the abstract, I promised to actually revisit an article of mine, which was published in 2017 in the International Journal of Refugee Law. So in that article, I was looking at temporary protection of Syrians in Turkey, and I was analyzing different aspects of this protection framework. After 5 years, I will revisit some of my findings there. And as to conclude, I will offer some conclusions on the temporary protection regime implemented in Turkey. So in this seminar, the first question I thought, okay, this is something that I have never explored, was that from the title of the seminar series, you can understand this is about Global South. But when you think Turkey, when I think Turkey as a Turkish citizen, Global South is not exactly the term I've been using. Global South is being used in commercial development and environmental contexts, and it does not have a set in stone meaning. But Turkey is a developing country. In terms of GDP, it belongs to developing countries class, but at the same time, Turkey has never been colonized, and sometimes Global South is being used for countries that are developing countries, but also they were colonized and they weren't able to access and use the natural resources, so on and so forth. So Turkey is a bit unique place in a sense that I wouldn't put it under the category of Global South, but at the same time, it is definitely not a Global North country. So in that matter, it has also this unique place that its strategic location is between continents, but at the same time, as I will mention in a minute, that Turkey maintains a geographical limitation to the 1951 Convention, which very few countries do. So, introduction to asylum system in Turkey. Turkey is a party to the Refugee Convention and the 1967 Protocol, but it maintains a geographical limitation. It is not obliged to accept refugees coming outside of Europe. Europe is interpreted by the Turkish decision makers as Council of Europe countries. So Turkey is not obliged to grant the refugee status for those coming outside of Europe, which are the mostly refugee producing countries. So Turkey is also a party to major human rights treaties, including ECHR, ICCPR, Convention Against Torture, Convention on the Rights of the Child. Turkey adopted its first asylum law following the Syrian influx, and this was in 2014. Of course, one of the elements which has affected protection of Syrians, but also other asylum seekers and refugees in Turkey, was the adoption of the EU-Turkey statement, which was concluded in March 2016. And in a minute, I will mention why this is relevant for protection of Syrians and other refugees in Turkey. And Turkey's new asylum, not so new anymore because it has been many years, but for me this is quite still new. Turkey's asylum law foreseen establishment of a migration agency, which we call DGMM. And DGMM was established and RST was done truly mostly UNHCR, but Turkish Migration Agency took over from UNHCR and is now doing all the refugee status determination and international protection determination procedures. When we look at the numbers, Turkey has been the country hosting the largest number of refugees so far. I'm not sure with the conflict in Ukraine if this will change, but I just updated the numbers for the slides, and the registered Syrians, the number of registered Syrians in Turkey is more than 3.7 million Syrians. And Turkey has an additional 400,000 asylum seekers and refugees from other countries. So Turkey hosts more than 4 million forced displaced persons at the moment. As for the timeline of the Syrian displacement began in 2011. And when I compare the numbers, for instance, this was a slower influx compared to what we are seeing in Ukraine today. Because in Ukraine, we have seen in nearly 5 days, as Sergio mentioned, 650,000 persons have been displaced. And I remember in 2011, when the first Syrian displacement began, the numbers were relatively lower than that. So for instance, in a few months, the number of displaced persons was 100,000 persons. So the speed of arrival was a bit slower than what we see today into the context of Ukraine. When Syrian influx began, Turkey didn't have an official asylum policy or a very comprehensive law dealing with asylum and migration. As a response to the Syrian displacement, but also to address some of the needs of the country in terms of asylum and migration, Turkey adopted, as I mentioned, its first law on asylum and migration, but also Turkey adopted the temporary protection regulation, which is a secondary regulation under Turkish domestic law, to respond to Syrian mass influx and to determine the legal status and the rights and entitlements of the temporary protection beneficiaries. And one of the instances which affected protection of Syrians, and this might not be seen relevant at first, was the failed coup attempt in July 2016 and the declaration of state of emergency in Turkey, because Turkey then suspended application of some of the human rights treaties and also changed its asylum laws to respond to some of the security threats at the time. It, for instance, abolished the suspensive effect of deportation appeals in 2016, but when the state of emergency ended and when the Turkish Constitution Court delivered a decision saying that removing suspensive effect from deportation appeals violates ECHR and Turkish Constitution, every change nearly returned back to normal. Now we are in a place where we are before state of emergency phase in terms of asylum laws. And of course, the EU-Turkey statement, I will mention in a minute, impacted and the EU-Turkey Joint Action Plan concluded in 2015 impacted protection of Syrians and other refugees in Turkey and restricted the right to seek asylum in Turkey to a certain extent. We have seen some amendments to the main asylum law and the TPR in the last few years. Also, I think a development which impacted protection of Syrians in Turkey is the realization of projects funded under the EU-Turkey statement through Facility for Refugees in Turkey, FRIT, which improved access of Syrians to certain rights and entitlements. Okay, so the law on foreigners and international protection, Turkey's first asylum law, was pretty much copy-paste from EU asylum acquis. And this is something quite interesting for me because it is an improvement in terms of the rights and entitlements of the Syrians and other refugees, because since Turkey didn't have any primary legislation dealing with asylum and migration issues, there were an absence of legal safeguards which provided in the legal instruments. So with the adoption of the law on foreigners and international protection, the law has a clear prohibition of reform on. The new law introduced some international protection categories, which is the conditional refugee status, which is the status given to non-European refugees. But in terms of rights and entitlements, there are many similarities with rights of refugees. Turkey also introduced subsidiary protection status, which is quite parallel to EU's qualification directive and its recast. In Article 15C, it copy-pastes Article 15C and B and A of the qualification directive. And so the new law clarified the rights attached to these protection categories. It introduced humanitarian visas, but more importantly, when the Syrian influx began, Syrians were the borders were open and Syrians were directed to tent camps at first, but then when it became clear that the numbers were increasing and it was not a very short-term war that we were facing at the time, the Syrian civil war, then the tent camps became prefabric camps and then reception centers, and then now 99% of all Syrians live in rural and city areas. They live in their own accommodation. So as I mentioned, the law also founded Turkey's first migration agency, clarified international protection procedures, appeal procedures. So in terms of the rights and entitlements granted to asylum seekers and refugees, I think this is a very decent piece of legislation which has the same safeguards, mostly the same as the EU asylum acquis. So when we come back to protection of Syrians, when we look at the admission of Syrians to the Turkish territories, Syrians didn't need a visa to enter to Turkish territories when the conflict first began. And Turkey decided to keep its borders open. So for a few years, Turkey's borders remained open, and any Syrian or refugee or Palestinian stateless person living in Syria who wanted to seek refuge was accepted as temporary protection beneficiaries it was a group recognition, so there was no individual procedure to determine whether a person, a Syrian, really qualified for any of the protection categories. So over the years, with the number of Syrians increased in Turkey, and Turkey became a bit overwhelmed with the number of Syrians and were struggling to provide effective protection. And as the security threats increased, but more importantly, when the EU-Turkey statement was concluded, and the objective was this statement was to end irregular migration from Turkey to the EU pressured Turkey in a sense to prevent new arrivals to the EU by making it harder to reach to the Turkish territories as well. So the borders were nearly closed in 2016. And when we look at today, the borders are still pretty much closed. I was checking which border crossings was open, and among nearly 20 border crossings in the Turkish-Syrian border, only one is available or seem fully open now. So
can you please move towards the conclusions? Thank you.
Oh, okay. Sorry, I'm way over time. Okay, so The rights of Syrians in Turkey. Syrians have access to healthcare, education. A limited right to work was introduced in 2016. And as the EU-funded projects became more and more developed, there are really certain projects which improved access of Syrians to healthcare, work, and education. And I can just answer questions about there. As for Syrians' access to RST procedures and durable solutions, when the temporary protection ends, Syrians might apply for international protection, but temporary protection has been going on for nearly 11 years now, and there's no end in sight. And Turkish presidency has made no declaration as to what will become of Syrians who are temporary protection beneficiaries in Turkey. Repatriation is not an option because Syrian civil war still continues. Resettlement is only available for very few, because only so far under the EU-Turkey statement arrangements, less than 40,000 persons and refugees, Syrian refugees, have been resettled to the EU, for instance. And this leaves integration at the host society the only option, a viable option for millions of Syrians. But Turkey needs to adopt comprehensive integration policies, which has not done yet, and needs to end temporary protection regime and provide Syrians as refugees a viable option to stay in Turkey legally. And that concludes my presentation. Thank you very much.
Thank you, Meltem, for keeping it to the time. Thank you also for your introductory remark on the notion of global South, and your invitation for us to really think, where is this term coming from, and when is it used, how is it used, what connotations does it bring in the migration debate? Thank you so much for that. Also for bringing into light again the fact that one sole country is hosting, more than 4 million displaced people. So when one brings that conversation into an EU of 27 member states, I think that puts things into perspective, similar to the example that Leisa mentioned on Colombia. And your last question of, temporary, how long is temporary, and the non-possibility for those people to apply for refugee status, full refugee status, and an asylum status, entitling them for security of residence and a full set of rights. So thank you, Meltem. Now, another country that is hosting a large number of displaced people is Bangladesh. According to UNHCR statistics, Bangladesh is hosting around 880,000 Myanmar displaced persons. We have with us Professor Mahbubur Rahman, University of Dhaka, and his presentation is Refugees Without Refugee Status, the ad hoc patterns of protections in Bangladesh. You have the floor. Please keep it to 15 minutes.
Thank you. Thank you for giving me the floor, Sergio. So in my presentation, I will basically highlight one thing, and that is that there is absence of any right-based protection mechanism for refugees in Bangladesh. And for many years, human rights activists in Bangladesh, academicians, they're stressing that we should have a right-based protection mechanism for refugees. And also international actors are also pressing for this. But the problem is this is not happening. The policymakers are preferring not to go to a legal protection mechanism for the refugees. So in my presentation, I will try to basically examine what are the roadblocks to the legal protection mechanisms. So in introduction, first of all, I should say a very few words about the current refugee situations in Bangladesh. Bangladesh is dealing with a deeply protracted refugee situation for many, many years. And the entire refugee population in Bangladesh exclusively comprises of the Rohingya population, an ethnic persecuted minority of based in Myanmar. And historically, in different times, fleeing from military persecution, this Rohingya population have taken shelters in Bangladesh. In 1978, there were more than 200,000 Rohingya people came to Bangladesh. And later on in 1991, more than 250,000 people came. But subsequently, through bilateral negotiation, most of them were repatriated. that the biggest influx of Rohingya population that became a challenge for Bangladesh happened in 2017. Almost 1 million people came after 2017. And the latest statistic says that the number of population is 920,000. So it is almost 1 million people. So these 1 million people are now mostly sheltered in the camps. Some of them are housed in an island. So since 2017, Bangladesh have sheltered them, and Bangladesh also signed an MOU with Myanmar for repatriation. But unfortunately, there is no noticeable progress. Now, whenever we try to determine the legal status of the Rohingya population now in Bangladesh, it seems that they are in a legal void because Bangladesh doesn't have any domestic law dealing with refugees or granting asylum status. And Bangladesh is also not a party to the 1951 Refugee Conventions. So legally speaking, the Rohingya people now in Bangladesh are subjected to the Foreigners Act. In other words, legally speaking, they are illegal migrants. So there is no law for their protection. However, Bangladesh is a party to the Convention Against Torture, and Bangladesh officially respects the principle of non-refoulement. And in a recent judicial decision, it has been held that principle of non-refoulement has already become a customary norm of international law, and as such, binding on Bangladesh. Now, for many years, the policymakers of Bangladesh are dealing with the refugee populations in an ad hoc manner. From time to time, their policies are changing. For example, when the Rohingya population came in 1991 and 1992, at that time, 35,000 Rohingya population were given refugee status officially. But interestingly, it was not done through any law. It was done by an executive order. So far, Bangladesh has not officially recognized any person as refugee other than those 35,000. Subsequently, in 2013, the government adopted a strategy paper on how to deal with the refugee population. And after the adoption of this strategy paper, the Rohingya population now who are in Bangladesh, they are not treated as refugee officially. Officially, they are treated as forcibly displaced Myanmar national. And if we look into the strategy paper, we'll find that this strategy paper does not speak about any rights of the refugee. It facilitates the hospitable protection of them. That means the Rohingya population now in Bangladesh are like guests. So we'll treat them like guests. So they are guests without any rights. So these instruments speaks about some protection of the refugees, which is limited to basic medical care, supply of potable water, extending sanitation facilities, and some other essential humanitarian services. And this strategy paper and also the other current policies do not support the granting of refugee status, do not support the right of mobility and right of employment. Now, in this context, certainly the question is what policy implication could be, what policy intervention can be adopted for better protection of the refugees. Ideally speaking, a comprehensive law can be a very good solution. An accession to the 1951 convention can also be beneficial for the refugees. But the problem is that the government does not seem to prefer any of these options, because policymakers are too hesitant toward extending comprehensive legal protection. Now the question is, why the policymakers are so much hesitant? So I will basically identify and refer to three factors. Obviously, while referring to these factors, I'm not defending the position of the government. what I'm saying is that these are the factors that discourages the government not to go for any legal protection mechanism. So unless and
You are muted, Rahman.
yes.
And please be sure.
Unless and until the local and international actors properly understand these factors and adequately address them, it is very unrealistic to expect a comprehensive legal protection framework from the policymakers. Now, what are these three factors? The first factor is the regional context. We have to understand the South Asian regional context. For whatever reason, I'm not going to the reason, but there is a very strong opinion in the South Asia, and that is that 1951 Refugee Convention is too Eurocentric. So it is not applicable for South Asian context. This is why, by far, no South Asian country other than Afghanistan has ratified or acceded to the Refugee Convention. And other than Afghanistan, no South Asian country has any domestic law on refugee. And if we historically look into the refugee situations in South Asia, then we will see that sometimes there are ethnic and religious conflicts. And whenever a refugee situation arises, the burden of refugee is too high. So when other South Asian countries, when the neighboring countries of Bangladesh are not acceding to the international convention, not adopting any domestic law, certainly it is natural for the Bangladeshi policymakers to think that if we go for a legal protection, then we will be overburdened compared to our neighbors. So to address this situation, what is more important is to focus on the regional context and to convince the regional actors so that they enact domestic law, and so that South Asian, even if 1951 convention is not credible to them, so that they can go for a regional convention or something like that. So adopting a regional framework and convincing the government to adopt laws in line with that framework can be very helpful in this regard. But these options are mostly neglected. The second factor is lack of clarity about the global compact on refugee implementation mechanisms. So Bangladesh has endorsed the GCR in international forums. But whenever there is some research on the attitude of the policymakers and the officials on GCR mechanism, it has been found that policymakers support some of the components of the GCR. They support the component on the burden sharing, but they are hesitant to go for full implementation of the GCR because they think that Bangladesh could be tapped in that GCR, because they think that if we open up the policies on self-reliance of the refugees, if we open up the policies on mobility of the refugees, we can do that. But after that, how will the rich countries share the burden? Because the framework of burden sharing is not very clear to the policymakers. So this is a factor which is discouraging the policymakers to go for a complete implementation of the GCR. So if we can present a very workable and very realistic burden sharing framework, then certainly the policymakers would welcome the GCR and faithfully implement it.
Man, can you please conclude?
Yes, the last point, and the last point is that there is some hesitancy in the policymakers about the role of the international actors. In some informal discussion and in also some public speeches, the policymakers have focused that international actors are talking too much about the responsibility of Bangladesh in dealing with the refugees, but they are not equally focused on the on ensuring the accountability of the Myanmar. And they're also thinking that most of the international actors are looking for just one durable solution, and that is integration. They are overlooking the other options. So, and also there are some geopolitical, regional politics and other realities. So if we can ensure, trust, we can ensure that international actors are more credible to the government, and government is more credible to the international actors, then certainly slowly we can expect that at some point of time we can go for a legal protection mechanism for the refugees. Thank you.
Thank you, Rahman. Yes, the situation of Rohingya is extremely worrying and quite concerning, frankly. And it is interesting that national courts are taking up the role of upholding and declaring universal principles like non-refoulement as customary international law, irrespective of what the government of the day, decides in its own politics to do or not when it comes to upholding protection and dignity of people. But also, indeed, Bangladesh is part of many international human rights instruments, and as such, it's bound by them. And non-refoulement is also part of that, as you rightly mentioned. It also qualifies expelling people unlawfully as crime against humanity. So this is something that has brought to the attention of the International Criminal Court prosecutor, and this is an issue to be, extremely, cautious about and diligent about as regards presenting the situation in the country. Thank you also for laying down the specific, regional and local considerations and the, the policymakers, of course, interest there. It's been fascinating. I mean, just to lay down or to remind us all about the Bangkok Principles on the Status and Treatment of Refugees of 2001, which have been developed by ASEAN African Legal Consultative Organization, which advises 47 member states on matters of international law, and we're providing a refugee definition and including also countries from Asia, some of the ones that you mentioned. So now I've seen a number of people that have raised questions. Thank you so much, and please feel free to upload your questions in the chat option and follow the ASILE project Twitter. I invite you to have a look at our Twitter account in ASILE and the MPC Twitter account as well. Thank you to those who have already uploaded their questions. I have a couple of them for Lisa, which brings back an issue that has been, I think, prevailing in the background of your presentations, and which is discrimination. Inequality of treatment by some of those, alternative group-based temporary protection instruments that only apply to certain nationalities. So the question for Lisa is, what about the situation of Haitian nationals in Brazil? How can we bring in and tailor in the way in which the Brazilian government is dealing with those and the inequality of treatment discrimination that exists at times of those people to have access to the options that Venezuelan nationals have? Is there a South American approach to that matter as well? And then for Raju, would like to answer this, Lisa, immediately?
Okay, thank you for these questions. Regarding Haiti, well, what Brazil didn't apply Cartagena definition to Haiti. It created a humanitarian visa that has some provisions that apply to natural disasters. And there's a very big debate within Brazilian legal scholars whether some kind of climate refugee figures should be created, legal figure. And if you're interested, I can share some of this literature with you. Regarding discrimination between nationalities, well, the approach that I just explained, it only applies for Venezuelan nationals. This is the policy response that Brazil has applied to Venezuelan nationals only, not to Haitians. discrimination really depends, and regarding Venezuelans, there are many concerns of the access to regular status for some minorities of Venezuelans, especially indigenous minorities. There are many problems with that group in particular. Discrimination regarding nationalities, well, it really depends on the nationality. And there's a lot of literature by some great Brazilian scholars, Shubilut, Apolinario, Czarodziński, who go into detail and explore these topics. And I can recommend them to you if you're interested. And then regarding the South American approach, no, there's no South American approach to refugees. There's just the Cartagena definition that applies to almost all of Latin America. And I can share with you in the chat box if you're interested an article on this. So I don't take much longer.
Thank you, Lisa. In fact, indeed, the United Nations Global Compact on Refugees refers also to regional approaches and systems on refugee protection which have been developed. So as to take up what also Rahman was saying, to take also the regional approach and also different understandings of that have been developed as to who qualifies or not as a refugee, which even extends beyond the Geneva Convention definition. Meltem, there was also a question for you. Perhaps you could also mention about the question of nationality discrimination. There was a question on refugee status determination. So a question by Stephanie Aker. UNHCR's preference is obviously that states do their own RSD, like Turkey. Do you have any sense as to how, capacity for conducting this is built up? And quoting the question, how long it's taking for them to process the claims?
Thank you, Stephanie, for the question. Let me start with your question first. Well, UNHCR was co-doing RSD before 2018, which is not very usual because although UNHCR was mainly doing RSD in the beginning, then they started to collaborate with a Turkish NGO called ASAM, and they were doing RSD together for a few years because the Ankara office in UNHCR did not have enough person to do RSD as the number of asylum applications rose in, and this was after 2012. So although Syrians are not going through RSD because they are granted as a group temporary protection, but nevertheless, the number of international protection applications have risen in the recent years. Under law, RSD should be maximum for 6 months, and it can be extended up to a year. But we know from practice that it goes more than that because so the GMM was just built when the Law on Foreigners and International Protection was introduced. They had to hire new personnel, and they were hiring nearly 1,000 personnel per year in the beginning. So, and only a very few of them were lawyers and law graduates. So they had to train everyone together. And UNHCR was doing mostly the capacity building in terms of RSD. But how RSD works in Turkey, Turkey has 81 provinces, and DGMM has a local office in every 81 provinces, and they have personnel there doing RSD, which was very difficult for every staff in each province. And they're like, Istanbul is a province and it is millions of people and hundreds of asylum seekers, but you have some provinces with very few people and asylum seekers. So their staff was even more and less experienced about RSD. And as a result, RSD was a major issue in Turkey when the DGMM was first established, but they have been doing capacity building for years now. And the capacity building is done by UNHCR for SD, IOM for other like removals and administrative detention. And I think to an extent, Turkey has increased its capacity, but of course it is not the same as UNHCR officials doing RSD because they are more experienced. Refugee law is a new area in Turkey, whereas you have less trainers than anywhere else. And as I mentioned, so in Ankara, they started regional RSD centers to have more harmonized and unified procedures. And now they have a few regional centers in Ankara to do it more quickly and to have more uniform results. But it is still early to see the results of whether the RSD is done properly in line with the Refugee Convention, and that the time limits are changing depending on which provincial office is doing RSD. Yeah. And I think Sergio asked me about the nationality aspect, if I'm not mistaken. Well, with temporary protection, you have always sort of have a group protection. So you need to protect those fleeing a certain conflict, fleeing a certain country, experiencing armed conflict or non-international conflict. Therefore, the first way to do is to protect all nationals of that country. Like in the Turkish case, all Syrian nationals are eligible for temporary protection, but also Turkey decided to also protect refugees, asylum seekers, and stateless persons in Syria seeking refuge in Turkey as well. And I think this can be a good precedent for the EU case too. Thank you.
Thank you, Melton. Yeah, I think the question is indeed what happens, for example, Afghan nationals or people coming from other countries, in Asian countries, in Turkey. There is a question for Rahman, posed by Andrew Guedes, director of the MPC, who raises the question: what about UNHCR and IOM in Bangladesh? What role do they play? Is there any tension between them? And what are the implications for protection in the country?
Okay, thank you. So officially speaking, there is no tension. Officially speaking, there is no tension. But I can say that back to a few years ago, probably 8 or 9 years or 10 years ago, UNHCR made an official publication. And in that publication, they talked about the deteriorating relationship with the government. But subsequently, UNHCR has always said that they have a very good working relation with the government. IOM has also said that. But yes, certainly there are some peculiar situations here. Because when I talked about the strategy paper adopted in 2013, in that strategy paper, the main international actor involved was IOM, not UNHCR. So although the situation is about refugees, but refugee was not the lead actor there. IOM was lead actor. Now, we certainly do not know what are the reasons behind this. Is it because of any competition between these two organizations or because of the bad relationship with UNHCR? We are not certainly sure about that. Another possible explanation that is sometimes heard from it is that when it was done, it was in 2013. At that time, we had a foreign secretary who had a long career in IOM, right? So it could be that because of his long career and long involvement with IOM, he was in favor of, he was more comfortable to work with IOM. So that could be another reason. So it is very difficult to say whether there is any tension in between these three actors. But yes, certainly there are some peculiarities which are apparent and which give rise to any sense of tension. It could be. We are not very sure.
Because of course this is linked with to Bangladesh government position on the Global Compact on Migration. The United Nations Global Compact on Migration. What's the position there? Meaning, are the authorities more favorable when it comes to the implementation of the GCM in comparison to the GCR?
If I compare to GCR and GCM, then I will say that yes, GCM is more on the road of implementation. Government is doing many things for implementation of the GCM, but comparatively, there is no such efforts seen yet for implementation of the GCR.
Okay. Because in fact, the GCM does provide quite robust also human rights guarantees that will be directly applicable to the situation of Rohingya as well, and that actually may have even more deeper implications as to what the Bangladeshi authorities are supposed to be doing. So it's just an interesting aspect. Another question has just come up. What recommendations can be drawn for consideration by the EU from each of the presented case studies in Latin Ukrainian refugee situation. I mean, I will bring that question to each of you. If you have any comment in this regard, I know also that Meltem, in particular, she's been actually writing quite extensively through her PhD and subsequently about the EU Temporary Protection Directive. So I will perhaps give first the floor to Meltem, but also then invite Leisa and Rahman to comment on this. Meltem.
Thank you. That's a very interesting question and not an easy to respond it, but I will try. Well, the thing is about Turkey, Turkey admitted too many asylum seekers and refugees because they needed protection. But at the same time, Turkey didn't have the financial or personal human capacity to deal with the mass influx because it is a developing country. It has its own development and economic needs, but it tried its best to tailor policies. But the thing is that I think the Turkish foreign policy estimated that the Syrian war will end in a few months or weeks, or at least in a year it would be over. So all the temporary protection beneficiaries, and it was a de facto policy at the time, would return back. So it didn't think ahead and think what will happen if Syrian war will not really end. And then what I need to do when the time comes and repatriation is not an option. And like I have done my PhD on temporary protection. I have been working on it for years, and temporary meaning is time limited. In Turkish case, it is 11 years, and it is too much. I mean, there are studies showing that after 5 years, people integrate irrespective of whether they are refugees, asylum seekers, or migrants. They have networks, they integrate to the society. And many Syrians in Turkey are actually integrated in a sense because they go to school, they speak the language. I have at my university, I teach some Syrian students, and they're very good at their own classes, and sometimes better than their Turkish counterparts. And they have jobs and they have families, relatives here. So in a sense that even though a country does not have official policy to integrate, people still integrate, and you need to find a way to actually legalize their stay. And temporary protection is not temporary after a few years. So this is an important point to actually think ahead and think that if the Ukrainian conflict does not end in a week, in a year, in 2 years, then what will happen after temporary protection? I mean, the EU Temporary Protection Directive has a time limit, which Turkish legislation did not. So it's a good thing. But temporary protection in the directive is for 1 year. It can be extended up to 3 years. But 3 years is still a lot. And the EU policymakers should consider what will happen after the time limit finishes, and will then, because the long-term residence directive does not apply to temporary protection beneficiaries, so their temporary limited stay in the EU will not be counted if the legislation does not change for the time required for the long-term residence status. This is one thing to consider. The second thing is, when mass influx happens, the host states hosting large number of refugees need solidarity, and solidarity is actually contributing. So there is a burden sharing scheme provided under the Temporary Protection Directive. But it is primitive because it was adopted in 2001. It didn't have details. It didn't really think about the Dublin regulations and the latest version of Dublin regulations at the time. So burden sharing and responsibility sharing is key to providing effective protection to those displaced in mass influx situations. The EU needs to find a way and do better than what it did before in the 2015 migration crisis to actually distribute the burden financially or materially to respond most effectively to the mass influx situation. And thank you. I think I said a bit more than I prepared. Thanks.
No, that's extremely relevant and to the point. Thank you, Meltem. Leisa.
Okay, I think that Meltem's point is really excellent. So I will just add a small point on my presentation focus on practice, what happens and what is happening right now at the border between Venezuela and Brazil is something that is worth being looked at and analyzed, and it's worth paying attention to that because Brazil created something called Operation Shelter, Operação Acolhida, at the border with Venezuela, which is a massive operation which articulates basically 20, almost all the Brazilian ministries, almost all the international organizations that are present in the Brazilian territory, and the civil society, with collaboration of the private sector, to receive these Venezuelan nationals, provide them with shelter, housing, and vaccines, which is something that has been mentioned regarding the immediate reception of Ukrainian population arriving in Europe. So the key of this operation is articulation between an enormous amount of actors, and including the civil society, international organizations. All these actors are articulated for the reception of large amounts of people that cross the border every day. And the key for this, as I said, is the articulation. And the second point is using, in bureaucratic terms, using policy instruments that are already there. Temporary protection has its problems, but it's already there. And if it provides, at least in short term, a venue for regularization, because in bureaucratic terms, the procedures are faster, then that's maybe in the short term, a policy instrument that is worth being explored.
Thank you. Thank you also for coming back to the point of Melton to differentiate between immediate temporary protection and the need to think also medium and long term, and explore questions of regularization and access to refugee status. Rachman, very briefly, we have 1 minute.
Yeah, I'm quite confident. I'm quite confident that you will take positive measures for protection of these refugees, and there are standards already. But I have just one recommendation that I can recommend to the EU. I would say that treatment of the persecuted people alone cannot be the answer to such situation. Alongside, we should also ensure accountability for acts of persecution. Whenever there is large-scale human rights violation and large-scale international crimes, only focusing on the protection of refugees can be counterproductive. Rather, we should take such measures which will deter the production of such refugees. So, accountability for persecution is equally important to treatment of the persecuted people. Thank you.
Thank you to the three of you and all the participants who have been following us and raising questions. The ASILE project will continue the conversation, not only as regards different international experiences and policy instruments and the actors involved in relevant countries, but also in the European Union, and particularly, of course, we shall examine quite in detail the EU's responses to what is happening, what is unfolding now, quite sadly, from Ukraine to some European countries. So please continue following our work. And I would like to thank the three speakers as well for their excellent presentations. And thank you all very much, and wishing you an excellent continuation.